Hello.
Hi.
May I come in?
Yeah, please, sure. Hi, good morning. Please have a seat.
Okay, good morning. Thank you.
Okay, before we begin, allow us to introduce ourselves first. My name is Nushatla Alia. I'm a legal advisor at A&A Associate. We based in Kuala Lumpur. I've been practicing a law for approximately 12 years in personal injury claims, tort laws, and also general litigation. And this is my partner.
Good morning, Mr. Lim. My name is Siti Arisa Adriana. I am a legal assistant with E&E Associates. I have been practicing for about 4 years, focusing on personal injury matters, negligence claims, and civil litigation. It is a pleasure to meet you today.
So now we will be conducting this consultation together and assisting you with any legal concern arising from your matter.
Before we proceed, sir, may we know how you would like us to address you?
Certainly. My name is Daniel Lim Wei Jen. I am a businessman in the technology sector. You may address me as Mr. Lim or simply Daniel.
Alright, Mr. Lim, thank you for the introduction. We were informed by our clerk that you requested an urgent consultation regarding an incident that occurred at Grandview Mall. Before we begin, I would like to briefly explain our consultation process. So this initial consultation is provided free of charge. However, should you decide to formally engage with our firm after this session, we will provide you with a written fee quotation and also engagement letter outlining our professional fees, disbursement, and the scope of our legal services. Depending on the nature of the work involved, an advance deposit may also be required before we commence any legal action. Is that clear, Mr. Lee?
Yes, that's perfectly clear, Miss Alia. Thank you for explaining that. And if I may ask, is there anything important that I should take note of before we proceed with the consultation?
Certainly, Mr. Lim. Before we comment, we would like to assure you that everything discussed during this meeting is strictly private and confidential under solicitor client privilege. This means that any information you provide to us today will not be disclosed to any third party without your consent, except where required by law.
Okay. For that reasons, we encourage you to be as open and candid as possible. And even details that may seem minor and unfavorable could be legally significant and help us provide accurate advice.
The purpose of today's consultation is to understand the facts surrounding the incident, assess the strengths and weaknesses of any potential legal claim, and discuss the options available to you, whether through negotiation, alternative dispute resolution, or court proceeding.
And we may also take notes throughout this meeting to ensure that we accurately record the information provided. With your consent, we will proceed on that basis.
That's perfectly fine with me. I appreciate the clarification. To be honest, I just want justice and fair compensation for everything I've been through.
Sir, before that, may I know if you bring any documents or information with you today?
Thank you. So frankly, I am incredibly frustrated. The way that the mall management has handled this is completely unacceptable. To deny all responsibility after what I've been through is just adding insult to injury.
We completely understand your frustration, Mr. Lee, and we appreciate how stressful this has been. May I know exactly when the date happens and its the location?
I think it happened around March 5th, 2024 at Grandview Mall around 11:30 a.m.
Okay, so let's talk about March 5th, 2024. You were at Grandview Mall around 11:30 a.m. Can you take us through what happened in your own words?
So I was on my way to meet a potential business partner for brunch at a cafe on the second floor. So I got off the escalator, turned toward the corridor leading to the cafe, and then before I knew it, I slipped on a massive puddle of water and crashed hard onto the floor.
Did you see the puddle before you stepped into it?
No, I didn't. The corridor area was quite dimly lit, and the floor tiles were highly reflective and shiny. So the lightning and the floor surface surface completely masked the visibility of the water.
Were there any warning signs, yellow cones, or barrier put up near the puddle?
None at all. There was absolutely zero signage alerting pedestrians, and what makes me furious is that when I was on the floor, several retail tenants from nearby shops, a bookstore, a fashion outlet came out to help me. They told me that the specific area had been leaking for weeks because of a decorative water feature. They had lodged multiple complaints with mall management, but no permanent repair were ever made.
That is highly critical. Did anyone else observe the scene? What about the mall staff?
So I've been informed by a third party who reviewed the CCTV footage that a member of the cleaning staff literally walked past that exact puddle twice before my fall and did absolutely nothing about it. So furthermore, when I fell, it took the mall's emergency response team 15 whole minutes to arrive. No immediate medical assistance was offered, and not a single person from management even bothered to apologize to me.
Now, Mr. Lim, we need to advise you of the possible defense position. Grandview definitely would deny the liability. They might use the CCTV recording and claim you were distracted because you were using your phone and holding a hot coffee. They will also claim that a warning sign was placed earlier but might have been moved by other visitors.
That is a blatant lie to escape liability. Yes, I was holding a coffee, but I was absolutely not using my phone. I was looking exactly where I was walking. And as for the signs being moved, I didn't see a single sign anywhere in the corridor before or after the accident. I think they're just trying to shift the blame on me.
Take a deep breath, Mr. Lim. We totally understand your feeling. Can you tell me what was your injury due to this incident? Did you bring any medical report from the hospital?
So as you can see, my right wrist has been fractured and I have to have 6 weeks of physiotherapy during a total 9 days of in hospital. And no, I didn't bring my medical report, and I also suffer emotional distress due to this incident.
It's fine, Mr. Lim. You can send me a soft copy of your medical report through our email. Here is our business guide. Any further inquiries you may be done through the details provided.
Before we will discuss the legal elements in detail, Mr. Lim, it may be helpful for you to understand the legal position of both parties in this situation.
Yes, please. So I'm not familiar with this legal concept.
Under the law, you enter the Grandview Mall as a lawful visitor. In occupiers liability cases, a lawful visitor is someone who has permission, either express or implied, to enter and use the premises. As a customer visiting the mall for a business meeting and brunch, you are clearly entitled to be there.
So where does that leave the mall?
The mall management, as the occupier of the premises, is responsible for exercising sufficient control over the property. Because members of the public are invited to enter the mall, the management have a legal duty to take reasonable steps to ensure that visitors are reasonably safe while using the premises.
So basically, they are responsible for maintaining the common areas.
Precisely, areas such as corridors, escalator landings, walkways, and other common spaces are generally under the control of mall management. If a dangerous condition exists in those areas, the management may be required to take reasonable steps to remove the danger or warn visitors about it.
However, it is also important to understand that the law does not make the mall automatically liable simply because an accident occurred. We must still prove that the mall failed to act reasonably in the circumstances and that this failure caused your injuries.
I understand. So it is not enough that I fell. We also must show that they were actually at fault.
Exactly. That is why evidence such as maintenance records, a CCTV footage, and witness statements, previous complaints, and also a photograph of the scenes will be extremely important in this situation.
For the information you have provided so far, your position is that you were a lawful visitor who encountered a hazard that should have been addressed by the mall. On the other hand, the mall's position is likely to be that they took reasonable precaution and that you were partly responsible for the accident.
That actually makes sense. So dispute is really about who should bear the responsibility for what happened.
Correct, Mr. Lee. And that is exactly what we need to evaluate based on the available evidence. Okay, Mr. Lim, based on the information that you have shared with us today, there appears to be a reasonable basis for a negligence claim against the mall management, subject to supporting evidence. In this negligent case, we generally need to establish four elements. The first one is the mall owe you a duty of care as a lawful visitors. The second one is there was a breach of duty, for example, by failing to maintaining a safe environment or provide etiquette warning of a known hazard. The third one, the breach must have caused the incident. And finally, you must have suffered actual loss or injury as a result of the incident. One,
I understand, but what exactly is this duty of care?
that's a good question, Mr. Lim. The concept comes from a famous case called Donahue against Stevenson. In simple terms, the court decided that a person or a business must take reasonable care to avoid causing a foreseeable harm to others who may be affected by the actions. In your situation, as a visitor to the mall, the management has a responsibility to take reasonable steps to ensure the premises are safe for customers.
If I may add, Mr. Lim, Malaysian courts also have applied similar principles. For example, in the case of Stephen for Cheng Lun and others against Highland Properties, Sendirian Berhad and others, the Federal Court recognized that occupiers and property managers may owe a duty of care to persons who are affected by dangers arising from their premises when the risk is reasonably foreseeable.
Therefore, we are not relying solely on an English case. Malaysian courts also recognize the same fundamental principle that property owners and occupants must take reasonable care to prevent foreseeable harm to visitors. Furthermore, based on the information presently available, the mall may face a difficulty arguing that this incident was entirely unexpected. You informed us that the nearby tenants had previously complained about the recurring leak, and there is also information suggesting that cleaning staff had observed the puddle before the incident. If supported by evidence, this could indicate that the mall had prior knowledge of the hazard but failed to take adequate preventive measures.
So I understand a little better now. But honestly, I'm still worried. What if the mall keep insisting that I was careless and that the accident was my own fault?
That's a valid concern, Mr. Lim. In court, it is common for defendant to argue that the injured person contributed to the accident. This is known as contributory negligence.
So does that mean I automatically lose my case?
Not at all. Even if the court finds that you were partly responsible, it does not necessarily mean your claim will fail completely. The court may simply reduce the amount of compensation depending on the degree of responsibility of each party.
So even if I were holding a cup of coffee, I could still succeed.
Potentially, yes. Holding a coffee by itself is not unusual behavior in a shopping mall. What matters is whether your conduct was unreasonable and whether it contributed significantly to the accident. That is something the court will assess based on the evidence.
I see. So I guess that's a relief to hear.
At this stage, Mr. Lim, we are more concerned with the condition of the premises itself. From what you have been described, there are allegations of poor lighting, a wet floor, the absence of warning signs, and previous complaints made by tenants. Those are matters that could strengthen your position if they are supported by evidence.
Yes, exactly. That's what make me so angry. If they knew about the problem for weeks, why didn't they just, fix it?
That is precisely one of the questions we would want the mall management to answer. If they had prior knowledge of the hazard but failed to take reasonable steps to address, that could be highly relevant in establishing negligence.
So what about the cleaning company that they mentioned? They keep saying it's the contractor's responsibility.
We anticipated the argument. However, from a legal perspective, the mall management cannot necessarily avoid responsibility simply because they hired an independent contractor. If the management knew about the recurring problem and failed to act, the court may still find them liable.
That's good to know. So for a while, I thought I had no case because they keep pushing the blame onto someone else.
We understand your concern. That is why obtaining documents and evidence is extremely important. We want to assess the facts objectively and build the strongest possible case on your behalf.
So thank you. I feel more confident now that I understand the legal position.
Mr. Lim, I have received the medical report that you have sent through our email. So let's.
Thank you for the details, Mr. Lim. To move forward, would you like to officially appoint our firm as your legal representative for this case?
Yes, definitely, I would.
Okay, so here's a letter of engagement. You should read it first and then sign right here. Excellent. So now we can proceed to map out the exact details of your claims.
Alright, so let's look at the compensation you are seeking. You have outlined a total claim of 420,000 ringgit. Let's break that down so we can properly categorize it into special damages, which are exact financial losses we can prove with receipts, and general damages, which compensate you for your pain and suffering. First, we have 80,000 ringgit for your immediate medical expenses, the surgery for your fractured right wrist, and your 6 weeks of physiotherapy. Second, we have 150,000 ringgit in special damages for the missed business contracts and postponed tax deals during your 9-day hospitalization and recovery. Finally, we have 120,000 ringgit in general damages for your physical pain, the lingering headache from your mild concussion, your lower back tissue damage, and your emotional distress.
Yes, that is the exact breakdown. Every single cent is justified, given how badly my business and health have suffered after the incident.
It is also legally vital that we include an extra 70,000 ringgit for your future medical expenses right now, as you may need ongoing treatment. To secure this full amount, our immediate next step is to gather airtight documentary evidence. We will need you to provide us with the original copies of all medical reports, hospital bills, and physiotherapy receipts from your time in the hospital. And we also need any financial records, email or cancel appointments log proving that the 150,000 ringgit in lost business deals. Lastly, please give us the official names of the nearby bookshop and clothing store where you fell. This will help us find more workers or tenants who might be willing to give witness statement on our side.
On our end, we will formally issue a letter to Grandview Mall demanding that they preserve and hand over the CCTV footage and their internal incident reports. Once we review this evidence, we will send them a formal letter of demand.
However, Mr. Lim, we should also consider alternative ways to resolve this dispute before jumping into a long court battle. Specifically, we should look at the mediation and arbitration.
I want them to pay for what they did. Why should I negotiate? What's the difference anyway?
Think of mediation as a structured, private negotiation. A neutral third-party mediator will help us and the mall's legal team reach a voluntary mutual agreement. It is much faster, cheaper, and less stressful than a trial, and you keep total control over the outcome. If they refuse to offer a fair amount, we can walk away at any time.
On the other hand, arbitration is like a private court. An independent arbitrator will hear arguments and evidence for both sides and make a final legally binding decision. While it is more formal than mediation, it is much quicker and more private than a public trial, which keeps your business losers out of the public eye.
Hmm, I like the sound of keeping this private. And if mediation can get me my compensation faster without a multi-year court war, I'm open to it. So let's start with the letter of demand and see if they are willing to sit down at the table. So I will get those medical and financial documents over to your office by tomorrow morning.
Splendid. Thank you for coming in today, Mr. Lim. We will drop a comprehensive documentary checklist for you, and let's get moving.
Thank you. I feel much better knowing this is in capable hands.
Thank you, Mr. Lim.
You're welcome.
Alright, Arisa, let's decide what we actually have on the merits. The client's narrative is emotionally charged, but legally there appears to be a viable cause of action in negligence against the management corporation. Our task is to assess the available evidence and advise the client accordingly.
Agreed, the elements of duty, breach and causation appear arguable on the facts presently available. However, our primary battleground will be countering their pleadings on contributory negligence. This defense is clearly setting up a narrative that Mr. Lim was distracted by his mobile device and physically burdened. They will inevitably rely on Section 12, Subsection 1 of the Civil Law Act 1956 to seek a reduction in any damages that may ultimately be awarded by the court.
So it is a tried law that the burden of proving contributory negligence rests squarely on the defendant. I need you to scrutinize our local jurisprudence, specifically recent federal court and court of appeal decisions on slip and fall incidents. Let's see how Malaysian judges are currently approaching apportionment when a plaintiff is carrying a personal items.
We have a reasonable basis to distinguish our facts from the standard line of defense. Alia, in Latimer against AEC Ltd in 1953, the defendants escaped liability because they took immediate practical steps to elevate a sudden hazard. Here, the available evidence suggests a possible chronic and unresolved safety issue. The Grandview Mall management may have had actual knowledge of the recurring leak for weeks, and there appears to be an absence of warning signs or physical barriers. Whether this amounts to negligence will ultimately depend on the evidence before the court.
That may strengthen our client's position, but Jones against Leeward Quarries 1952 reminds us that if a plaintiff fails to take a reasonable care of his own safety and directly contributes to the injury, the court may reduce the damages accordingly. To properly assess the risk, our immediate procedural priority is discovery. So we require a CCTV footage to evaluate his line of sight, pacing and movements before the incident. Then we may rely on Section 114, Subsection G of the Evidence Act 1950 and invite the court to draw an adverse inference where appropriate. However, whether such an inference should be drawn remains a matter for the court's discretion after considering all the surrounding circumstances. What do you think about them trying to blame their independent contractor?
That depends. That defense may face difficulties if it can be shown that management had prior knowledge of the hazard through repeated complaints from tenants. If management knew of the danger and failed to take reasonable steps to address it, the court may still consider them responsible, notwithstanding the involvement of an independent contractor.
Excellent. So I think we addressed the quantum of damages. The 150,000 ringgit relating to the aborted technology contract would likely fall within the category of special damages.
Indeed, in Guan Sun Ting mining against Wong Fuk Kum, special damages must be specifically pleaded and strictly proven. Therefore, we should advise Mr. Lim that documentary evidence will be essential. Supporting documents such as letter of intent, business reports, correspondence, and cancellation notice may assist in substantiating the claim. Without sufficient evidence, the court may decline to award those losers or may award a lesser amount than claimed.
Precisely. So our role is to ensure that any claim advance on behalf of the client is probably supported by evidence. I think we need to draft a comprehensive evidence preservation letter to the Wong's legal counsel before the close of business today. putting them on notice regarding the CCTV service.